to the cloud. There we go, recording in progress. Okay, let's get officially started then. Welcome everyone. Listen, here's why you are here today. We are talking about form changes. If you received your license after July 1st of last year, you're about to learn your first thing. One is that this happens every single year. There are form changes. Just because there are form changes does not mean it's extraordinarily difficult, okay? So I'm going to walk through the offer to purchase and contract, probably the listing agreement as well. And I may just touch on the buyer agency agreement. Here's the first thing I want you to remember is that these are not radical changes this year. A lot of time what they did is they just simply moved something around. All of you have access to this through the NC Realtors, and I've posted it on our website as well. So you can download this form, and then when you click on it, it'll send you to an active link where you will see the same changes that I'm going to show you today. In a couple of weeks, typically the attorneys who drafted these forms will also post on ncrealtors.org .org. They will post a video saying what I'm getting ready to say right now. The only difference is it was done by the attorneys who drafted it, so it might help you get inside of their mind. With that being said, let's start looking at some of the changes and see if it makes sense to you what I mean by they're not dramatic changes. By the way, this is not the contract class. You're going to see me talk about a change, and then I will scroll to the next change. If you need a class on contracts, that's a different class where we sit around and we talk for an hour and a half about all the provisions of a particular contract, okay? So here we go. The first change that you see in yellow is that they are helping us identify mobile homes on properties. Now notice that there was a note last year that talked about mobile homes, and it said if you have a mobile home on the property, make sure to put it in the additional provisions addendum. So what they did this year is they changed it to a will or will not include a mobile home. So what you'll do is if it includes a mobile home, you will check that it will, and then it tells you to use the additional provisions addendum, and it tells you the name of the form 211T. And when you go to 211T, it'll ask you for like the VIN number and things like that. The purpose behind this is most of you are not dealing with mobile homes. However, as we start getting out into Sanford and Carthage and Lillington and Franklinton and places like this, you may run into a property that has a mobile home on it. And if I were you, I would question very quickly a couple of things. One, does it go with the property? And secondly, is it going to cause us a nightmare in regards to financing? So these are just kind of tips to kind of make everybody aware. Hey, stop everything. There's a mobile home on the property. Let's check it out before we get too deeply into this. Simple, simple. Okay, here's a good change that you will never know took place. Notice the yellow right there. We used to have options when it came to earnest money. Earnest money would be given either with the offer to purchase and contract or within 5 days. Well, one of the attorneys finally realized that the effective date is within 5 days. So why do we need two separate boxes for you to check? Because nobody was checking the boxes and there was unclarity about whether the earnest money is late. So when it comes to earnest money, you now have 5 days from the effective date of the contract to get the money into the trust account, according to this contract, okay? That way, if you have somebody from New Jersey who's mailing something down, they have time to get it here. Listen closely. This does not have anything to do with the due diligence money. Do you understand that that change is only about the initial earnest money? Do you see that? Okay. If you have questions or comments in between, feel free to stop me. But again, watch the pattern here, not major changes. This note did not change. This is the note that basically says, hey, if there's going to be an electronic transfer, that the seller agrees to cooperate with the buyer in making this so. The interesting thing is that apparently someone questioned, is a wire transfer an electronic transfer? To take any ambiguity out of the contract, what they did is they added the word electronic and wire transfer. So I doubt seriously if that changes anything about the way that you were doing business, but apparently some attorney felt like it was important to make that. Now it's there. I will say the more important thing about that paragraph right there is the thing that is not changed. And that is that if the seller agrees to take electronic or wire transfer, they have to cooperate. I can't tell you how many times I've had someone say, well, the seller said that they would take a wire, but they're not willing to give their banking information to the buyer. Well, if the buyer doesn't have anywhere to wire it, you can't blame the buyer for being late if you don't provide them that information. So this is a great conversation to have with your seller. Seller, if you want to accept a wire, how are you going to do that? Okay. Easy peasy. Look at this. All this stuff right here, nothing's changing. You know, I'm skipping the bottom right-hand corner because in the bottom right-hand corner, all it says is it was revised for the upcoming year. One of the things that you do need to know is that even though these forms do not change radically, what happens is their copyright ends at the end of the year. So if you use an old form, the form is still valid, okay? But you might be negligent in the eyes of the real estate commission. If something were to go wrong and you were using an old form, the commission could actually use that to discipline you. All right, getting into the fixtures paragraph, not a lot of changes, nice, simple, but there is one significant change and then one minor change. The significant change here, look what they did to the whole paragraph dealing with fuel tanks. Over the past 7 or 8 years, fuel tanks have been a thorn in the side of real estate agents. Now, you may never sell a property that has a fuel tank, but if you do sell a property that has a fuel tank, it could be leased or owned. If it's owned by the seller, it automatically goes with the property. If it's leased, the seller can't sell it because he doesn't own it. So what they've done is they've taken the fuel tank paragraph here and they've moved it to a latter part of the contract. And that later part of the contract, you'll see it completely matches your listing agreement. So going forward, the offer to purchase and contract will match the listing agreement. The questions that you ask the seller at the time you listed the property should be imported into the offer to purchase and contract. At the end of the day, it's actually a better change because it puts it all together. These other two changes, I don't think were necessary, but they did it anyway because they're attorneys. They get paid by the word, so they have to change some stuff just to justify their fee. Swimming pools, spas, hot tubs, excluding inflatable pools, spas, and hot tubs. Notice last year it just said excluded inflatable. And some people say, well, what about inflatable spas? What about inflatable hot tubs? So the attorneys came back and literally said, guys, come on. If it's an inflatable pool, inflatable hot tub, inflatable spa, it is not, it is excluded if it's an inflatable from being a fixture, okay? So just clarifying there. And similarly, when you look at this next one, where they put curtain/drapery rods, the way this read last year, it said curtain and drapery rods. So some people tried to argue that the curtains were fixtures and should stay. That was never the intent. It was always the intent for it to be the window hardware, meaning the curtain rods and the drapery rods, okay? So they just clarified that by putting a slash in there. Again, that's the way most of us were operating anyway, correct? Okay, notice again here, they scratched out fuel tanks and they said, it's coming up later. It's coming up later. But by the way, make sure that you identify any leased fuel tank. And we're going to talk more about it when we get to paragraph 7D, because where you're at right now is the fixtures part of the paragraph where we're identifying things that are leased. I just got a call right before I walked into this class today from someone who's dealing with this situation. Her seller has a leased fuel tank, and if everything goes well, the buyer will get with the gas company and they will create a relationship with the gas company and they'll just take over the lease, but they're not obligated to. And if they're not obligated to, we have a leased component on a property that the seller is going to stop paying because obviously they're not going to lease it any longer. So the solar panels, I would take those, they're not addressed right here. Having said that, I would address that because typically they're going to be financed and it's going to work more like a UCC filing, a Uniform Commercial Code filing, and the attorney will discover those on a title search and they'll probably pay those off out of one party or the other's proceeds, typically out of the seller's proceeds. But it's a good question. And that's the type of mindset that we're talking about. The question on the floor had to do with solar panels. Technically that hasn't changed, but the point that John was trying to make is you got to understand, are these leased, purchased, or owned? That's what we're talking about in that paragraph. And fuel tanks is the one that's had the major change. look at this, lots of pages here where we don't have a whole lot of changes. And then we get down to this note. And even though we have a change here, the theme of the note has not changed. What they're trying to do is make it easier for people to understand it at first blush, instead of having to think hard about what this means. So here's the deal. This paragraph has always said, and now it says it specifically, there is no loan or appraisal contingency in this offer to purchase and contract. If the house doesn't appraise, tough. You're going to have to buy it anyway, or lose your due diligence money or earnest money, depending on where you are in the contract. You can't get your loan, tough. You're still going to lose your due diligence money because this contract was never contingent upon you getting a loan. And people coming from other states still may be operating under the assumption that if they don't get the loan or if it doesn't appraise, they don't have to buy it. That is not the case in a due diligence contract. If you want to walk away, but you're not getting your due diligence money back, okay? Buyers advised to consult with the buyer's lender prior to signing this offer for the loan process and for the, of course, the appraisal as well. Make sure, buyer, that you're allocating sufficient time to make sure you're going to get the loan. And by the way, agents, if you don't think that house is going to appraise, let's go ahead and have that conversation with the buyer now. How do you plan on bridging that gap? I don't know. I think I'm just going to get lucky and it's going to appraise. Wrong answer. The question is, if it doesn't appraise, are you prepared to bridge that gap? Because let me take you back to line 1. You are not getting your money back. Okay. Technically not a change, just a clarification there.
Chris, I have a question on that.
Okay.
So does that mean we do not need to do appraisal addendums anymore?
You've never needed to do appraisal addendums. They've always been there basically to make the seller feel good. Appraisal addenda are not worth the paper they're written on, because the buyer can walk away for any reason or no reason during the due diligence period. Okay. They've never had a lot of value other than the fact that they make sellers feel good.
Okay, thank you.
Okay. Notice again, we're marking out the information about the fuel tank, and this information didn't go away. It just all moved down to 7D. So we'll get there in just a moment. Here's another clarification that the attorneys have made. Notice what it says here. You can see the part in yellow. I'm going to read the whole part. Repair improvement negotiations agreement. Buyer acknowledges and understands the following. Unless the parties agree otherwise, the property is being sold in its current condition. Do you understand what that's saying? This is an as-is sale unless you negotiate otherwise. I mean, that's 2 pieces of information right there. I can't tell you how many times I've had a buyer come up to me and say, "What did you tell me it was an as-is sale?" Like, we did. I mean, it's in every contract, but apparently now by putting it in bold, it's to help people understand you're buying this house in this current condition. If you can negotiate better, knock yourself out. But having said that, that should not be your anticipation at the time you enter into this contract. And then notice, to emphasize that, what the second bullet point says. Seller may, but is not required to engage in negotiations for repairs. Okay, we're not telling you to stop asking the seller for these repairs. What we're suggesting to you is don't expect them. They're not required to give them. Yeah.
When do they have to ask for the repairs?
When do they have to ask for the repairs?
I'm a seller and I signed this contract that says that, and then they ask for repairs. Oh, no, read your contract.
That they can ask for repairs up to the time of closing.
7D, whatever number you're on.
They can ask for repairs right up to the time of closing.
Right, and the seller can point to that section and go, "Oh, no, you signed it, that's it, I'm not gonna."
Oh, well, I mean, certainly that's going to be a matter of market negotiations, but buyer's agents, feel free to ask for something anytime. Just don't set the expectation that the seller has to fix it. In my last class, I added this for emphasis. I don't care if it's a safety issue. Seller still doesn't have to fix it. I don't care if it didn't meet code. Seller still doesn't have to fix it. Maybe if it was a new home, but that's typically a different contract. Okay. Do you notice they're just trying to emphasize some things here that have been fairly standard in the contracts in the past, but not clear?
So I just have a
Yeah.
question that even if they accepted a VA loan, you have to fix any repairs pertaining to the vehicle.
That's correct. Now, that means the house might not appraise. And if the house doesn't appraise, the buyer's not going to be able to complete the transaction if they can't get a full VA appraisal on the property. And if they walk, say again? They do not. There has not been a court opinion that says they get their due diligence money back if a VA loan does not appraise. There is no decision out there right now that says they would be entitled to their VA. The only opinions I've seen have been from attorneys who have said if a FHA or VA does not appraise, the way the paperwork is written is the veteran can't be charged something for nothing. But remember, due diligence, he actually got what he paid for, the opportunity to do diligence on the property. This is still subject to review, but in going on for years now, the attorneys have said, no, they're not entitled by virtue of that to their due diligence money back. Now, keep in mind, they would be entitled to their earnest money back up until the time of closing if they do not get if the VA property does not appraise, okay? Buyer representations, all good, nothing changed there. Okay, slight change to the Residential Property and Owners Association disclosure statement verbiage, but again, I doubt seriously if it's going to affect the way you've been doing business. Let me set up a scenario for you on this. Are you aware that if the buyer does not receive the RPOD before they make an offer, they have a 3-day right of rescission? That's what the law says. Okay, if you don't receive the RPOD before you make the offer, you have a 3-day right of rescission. And then there are boxes here that the buyer can check. Well, if the buyer checks the first box, he's saying that the seller has complied with the law. So you as an agent, you need to be careful here. If your buyer's going to check that first box, you need to make sure they have in fact received a completed RPOD. Okay, if they have not, check the second box. Okay, the second box says, no, I didn't get the RPOD in a timely manner. And even if they give it to you late, you're still going to have a 3-day right of rescission predicated on the date that you made the offer. Now, what happens if there's a counter offer? If there's a counter offer, if I was the seller, here's what I would do. I'd say, here's a copy of the property disclosure statement. Here's my counter offer. Why would I do that? Because now, have you received the RPOD before you made your offer? Okay. And so just be a little bit careful here. I have not had any come to my attention that have been a problem, but apparently this has been a little bit of a problem with buyers checking a box and saying, well, I never got the RPOD. Well, don't check the first box if you never got the RPOD. Check the second one. Make the seller give you the RPOD and correct the form. Okay. But it literally, that's such a minor tweak on a daily basis. It shouldn't affect the way you do business. Yeah.
So if they're countering, they should be giving you their RPOD 2 times. Am I saying that correctly?
Yeah, on the first offer, they never gave it to you.
Oh, okay.
Yeah,
But
but
if they gave it to you on the first offer, they don't need to give it to you on the second.
it would have been, if they gave it to you after the first offer and then they counter, then technically they would have fulfilled box 1 because you would have had it before the offer. Okay. After 3 days, after the 3rd day, you would be entitled to whatever the other parts of the contract. You can walk away for anything during due diligence, right? You just lose your due diligence money. If you backed away within the 3 days?
No,
After 3 days, you would absolutely. Even if the seller never gives you a RPOD, if it goes past 3 days beyond the contract date, you have no rights of rescission after that point. Okay. In theory, you would get your due diligence back if you terminated within the 3 days, if you had checked the second box. Okay, but remember, guys, never count on getting your due diligence money back, because the minute that that is given, it's in the seller's pocket, which means you have to go get it and get it out of the seller's pocket. So never promise anyone they're getting this. What I think is going to happen on these is simply that if you're a listing agent and someone checks the second box, I would smack myself in the head and go, oh crap, I forgot to give you the RPOD. Let me give you the RPOD and then counter offer with the first box being checked. In other words, just eliminate the buyer's right to the 3 days. That way you don't get into a negotiation about whether they get their money back or not. Does it make sense to you that the mineral oil and gas rights would have the exact same changes? Since it's the same law, it'll make the same changes. Okay, now responsibility for buyer's cost here. These have been reorganized, but the only thing that's a little bit different here is it tries to identify and clarify what charges buyer and seller would be responsible for in regards to the homeowners association. So what it says right now is, and we'll pick this back up in 9B, charges by an owners association or management company vendor as an agent of the association under paragraph 9B of this contract. Well, let me make it more simple for you. When would buyers be responsible for homeowner association fees as part of the closing? Well, the only time that the buyer is going to be responsible is if it's something like, have you ever been involved in a transaction on a new home? And in a new home, oftentimes they require a capital contribution fee. The buyer pays that. Have you ever been in a situation before where the buyer says, I'd buy that house if I could put a fence in the yard? Well, then buyer, you need to pay for that research and that architectural review because the seller doesn't care whether you have a fence or not. Those are the type of things that the buyer would have to pay for upfront with the HOA. Obviously, once they move in, they'll pay the regular fees associated with that. So we have some more clarity coming. It'll show up in 9B, but all we're talking about is how the HOA costs are going to be distributed at closing. I told you that the fuel tank information was going to be put right here, and it's all together. And I hope that what's going to happen is you'll start seeing that it is exactly as it is in the listing agreement. That should make your life easier over time once you get used to doing this. It actually made the contract a little bit longer because they put some more information in here, but it'll be consistent with your listing agreements. And here's what that information is. Tank 1, do you have a tank? Is it leased or is it owned? If it's leased, who's it leased from? And then once the buyer knows that it's a leased tank, the burden is on the buyer to do the research. You see that in paragraph 4, the buyer's due diligence, where they say, buyer, if you're concerned about the fuel, you need to check that out as part of your diligence process. So I think this will actually help over time. Now, I'm getting ready to point you to the one thing that actually is different than last year's contract. So I'm down here where it says tank and fuel. So I'm going to read this. I'm going to read it slowly, and I'll tell you what the difference is. Tanks included in the sale. Buyer and seller agree that any tank described above is owned by the seller, shall be included in the sale of the property. Simple, simple. If the seller owns it, it's included in the sale of the property, unless they excluded it in 2E and 2F. Nobody's going to exclude a fuel tank that they own. Okay. Now, fuel, this is the difference. Seller may use fuel in the tank described above through settlement. Now, typically speaking, this time of year, you're not using a lot of fuel, right? For the most part, if you're using fuel this time of year, it's probably running like a water heater or something to that effect. Obviously, in the winter, you're using it every day. So what this says is the seller may use fuel as described above through settlement. That hasn't changed. Keep reading with me. But may not otherwise remove fuel or resell it. In the contract that you are literally using today, it says that the seller has a right to remove the fuel from the tank and be reimbursed by the fuel company. That is changing. Seller, if you're using your fuel for legitimate means, then use it. If it's winter, fine, use it. You got to heat the house. And you also have to make fuel available for inspections, right? Okay. But if there's, and it was interesting, the conversation I just had on the phone about a fuel tank, the fuel tank is full, okay? Under the old contract, the seller can be reimbursed for that. Under this new contract, the fuel will be treated like any other fixture. Seller, if you have a lot of fuel in that tank, you're not going to get paid for it. You need to figure that in your negotiations on price. Trust me, this is going to make your life better, okay? Because then you don't have to worry about sellers calling you and say, hey, who can I come and get this fuel out of this tank? Hey, how much are they going to pay me? Hey, this or that. Can I do it myself? No, there's a law that says you can't stick a garden hose in there, suck it out, and take it with you, okay? That's against the law. So anyway, over time, this will make your life more simple. The difficulty is going to be when the person on the other side of the transaction doesn't know the contract's changed, because they may tell their seller, just go take the money back, get reimbursed that $250 or whatever. It's not the case after July 1st if you use the new contract. Seller's use of fuel in any tank is subject to obligation under paragraph 8C. You haven't seen that yet, but 8C is where it says that there must be working utilities through the date of closing. Okay, make sure there's enough fuel in the tank so that the buyers can do their inspections. Couple of notes here, but we're back to stuff that's been said for a while. Buyers shall be entitled to conduct inspections to confirm the existence, type, and ownership of any fuel located on the property. That's exactly what the old contract said. It's just been moved. Buyers advised to consult with owner of any lease fuel tank regarding the terms under which buyer may lease the tank and obtain fuel. That is new, and it clarifies what the buyer should be doing once they go under contract. Treat leased fuel tanks as material facts. Make sure the buyer knows to do the research on this. State law provides it's unlawful for any person to suck it out of the tank. They can't mess with those connections, okay? The fuel company could right now, but individuals cannot. Okay, owner association charges, we have already seen this, and what you see is you see the mark out here telling us that it's going to come up in just a moment. The paragraph that we're in right now is actually provision 8 of the contract actually deals with, let me make sure I'm correct on this. Yeah, provision 8 of the contract deals with seller obligations. So you'll see some things that were moved from obligations or moved into obligations. The interesting thing about a seller obligation is it's something the seller has to do, or they would be in breach of the contract. If it falls into another category, it might not carry the same weight. But here's the deal, seller. Any charges by the owners association or management company as agent of the association will be described in paragraph 9A. And we will again address what the seller pays and what the buyer pays. We've just moved it around a little bit. Interestingly enough, home warranty was moved into the seller obligation paragraph. This used to be lower, and they moved it into the seller obligation paragraph. Listen closely to what I'm saying. It still does not require the seller to provide a home warranty. What it does, it says if the seller said he was going to provide a home warranty in this contract, he is obligated to provide that home warranty. And if not, he'll be in breach of contract. So that was the significance of moving it into paragraph 8. The note down on the bottom is just good advice. If you're selling home warranties, which I actually do believe you should be, but having said that, please make sure that the buyers understand the limits, of what these policies are. For example, pre-existing conditions, how is the home warranty going to cover that? There's probably going to be a visitation fee for going out and looking at the air condition to see if it's working. So a lot of people think home warranty, wow, I never have to pay for anything. But yeah, let's not be naive. I mean, there's some things that are just not covered, just like on your health insurance, there's some things that are not covered. Okay, we've talked about this a couple of times, so we've just moved all this together, and here's what it says. Homeowners associations are going to be a pain in your side, so make sure that you understand as well as you can. Look at A, talks about what the seller is going to pay for. Fees incurred in completing the RPOD. If the seller has questions about how to complete the RPOD and they go to the HOA and the HOA charges them $125, sorry, seller, it's your job to get this information, so you're just going to have to pay it. Similarly, in item number 2, fees required for confirming the seller account information. The attorney is clearly going to want to know if the homeowner association fees are paid, right? So if the seller needs to provide this document, and if the HOA charges for that document, seller's just got to pay it. 3, any fees charged for transferring, update, and ownership of the records. I can remember when this cost $0. I can remember when this was $25. I have seen it as much as $325 for the homeowner association, literally to just change the name from the seller to the buyer. Seller, you're going to have to pay that. That's what the contract says. And the reason that the seller pays it, this is the logic of the attorneys. The seller is in the best position to negotiate with the HOA right now. They're the ones that own the property and pay the bills. So if my HOA said, we're going to charge $325 for that, I want to say, really? You want to charge me $325 to type in somebody else's name in the computer and delete mine? Seems a little much. I'll give you $150 for it. That's why the seller is in charge of that. Yeah.
The last 2 transactions that is not transfer fee,
I'd have to see the fee. Are you sure it was not a, was it a new home by chance?
no, it was in,
Interesting. Unless they had negotiated it, that's typically going to be a seller cost according to the, if you use the standard offered purchase and contract. Yeah, that changed actually about, 8 years ago that they put that burden on the seller because of the logic that I described there. Now, remember, we'll get into in just a second, we'll get to what the buyer should pay. Okay. And then finally, you see there, any other fees that are not going to be paid by the buyer are going to be the seller's fees. So let's look at what the buyer is going to pay. I mentioned these just a moment ago. Number one, charges for providing information required by the buyer's lender. And Christina, this is not new. It's just been moved. That's why it's in yellow. But if there's something that the buyer's lender needs, clearly that should be a buyer cost, not a seller cost. Working capital contributions, I mentioned just a moment ago. Typically, you'll see these in new homes. Or other charges imposed for buyer's use of common elements, and then determining restrictive covenants. That was the example of the fence that I gave. The seller doesn't know whether the buyer wants a fence or not. If the buyer wants a fence, he should pay for the HOA for the architectural committee or whatever. Okay. Home warranty, you can see scratched out there because we moved it up into paragraph 8. You know, this paragraph right here is actually an important change, but I hope you haven't run into it, and I hope you never will run into this situation. Condition of property at settlement, it used to be all, and risk of loss used to be all in one paragraph. But the reason that became problematic last year and for the last couple of years, the contract has literally said that if the property is substantially damaged, there's this paragraph in there that says the property should be delivered the same way it was contracted on, right? I contracted on it and everything was good. And then we go to closing and the carpet burned because something rolled out of the fireplace. Come on, that's not fair. So this paragraph has always been in here. And in regards to condition of property and settlement, last year, as recently as the contract you're using right now, here's what it said. If the buyer ends up, or excuse me, if the property ends up being damaged and the buyer chooses to walk away because there was a fire or a water leak or something like that, a major water leak, if the buyer chooses to walk away, it's fine, but the buyer is going to lose his due diligence money and get his earnest money back. Well, what they looked at and a lot of complaints they had last year said that's not fair. If the property is not in the same condition at closing as it was at the time of contract, it seems like the seller would be in breach. But that was not the interpretation of the contract. It is now, after July 1st. And to give you an example of one that we had in-house, we had a buyer, and I can't remember which side that we were on, but buyers under contract, and a pipe burst in the ceiling, runs down a wall. Wall has to be ripped out. Part of the kitchen has to be ripped out. Ceiling has to be ripped out. This is a major, major repair that needs to be done. You know, at one point, the buyer's trying to weigh these two things. Do I walk away and get my money back, or do I stay in the contract and basically get a new interior house after the work's been done, but it'll take several months? Well, as it turns out, the buyer couldn't walk away and get their money back. They could get their earnest money back, but because of the way this paragraph was written, they could not get their due diligence money back. And you know how due diligence has been the last couple of years, right? So they would have been walking away from $20,000 or $30,000 if they had chosen to walk away. And they couldn't go after the seller for that money, given the verbiage of the contract. So anyway, I hope you never have to worry about this, but condition at closing, if a storm happens, if a fire happens, the house is damaged and the buyer chooses to walk away, they should in fact get their due diligence money back if you use the new contract after July 1st. Okay. Risk of loss has been moved, but it has not changed. It used to be part of the above paragraph. They've now re-separated it so that it says the same thing it always has. I don't want to get into a conversation about risk of loss, but I'm going to tell you guys, watch out in regards to risk of loss, because that affects things like buyer possession before closing and seller possession after closing. Who's responsible for what? And this is also addressed in your possession documents, okay? Make sure if somebody moves into a house before they own it, that everybody understands what's insured and what's not. If a seller stays in beyond closing, they can't have homeowners insurance anymore because they don't own the home at that point. So they would need rent insurance or something to that effect. So anyway, I don't mean to go down that tangent, but that is actually an important paragraph given the way that we're doing business today. No changes here. This all looks. No, not under that paragraph. It only says now the due diligence money. And the reason that they would not be entitled to the ancillary costs is, in fairness to the seller, the seller had nothing to do with the fact that the house burned or flooded or something to that effect. So they didn't feel like they wanted to punish the seller for that. I had to go back and read it, just make sure I was telling you correctly on that. But yeah, so we're in good shape on that. Let's see. Okay, we're now down to breach by the parties. What happens in the event of a breach? Well, here's the deal, and try not to get into arguments with people about this. If the buyer breaches, what is the maximum that the buyer loses under this contract? Due diligence, technically, they don't lose the due diligence. They got what they paid for. They got the opportunity to do diligence. The worst that could happen, according to this contract, is they lose their earnest money as liquidated damages. In other words, seller don't go after any more than the earnest money because it limits it to just the liquidated damages. You can see it in that paragraph, not a change. The thing that has changed, really changed only in verbiage. It did not change by virtue of the law. Breach by seller. If the seller breaches, the buyer has always been entitled to their due diligence, their earnest money, and any monies that they have spent in a reasonable effort to acquire the property, such as Inez was talking about just a moment ago with the inspections and stuff like that. This has always been tacitly implied, but now they specifically put it in the contract. If the seller just flat out changes his mind, the buyer could sue him for specific performance. That's always been the case, but now they've actually put it in words here. So, or they could elect not to terminate, the buyer could elect not to terminate, instead treat the contract as remaining in full force and effect and seek the remedy of specific performance. Again, let's not play attorneys on this. If a seller gets ready to back out of a contract for one reason or the other, you're getting your buyer in touch with an attorney at that point. You're not trying to work this out on your own. We can't control whether the seller walks away from a contract or not. All the attorney can let them do is know what the penalty for walking away from a contract is. Hard coded into the contract now, not a radical change. Okay, signature pages and all that stuff looks very, very straightforward. Okay, questions or comments on anything that you saw there? All pretty straightforward. I don't see any questions in the chat. Okay, let's go take a look at another document, but these actually work fairly quickly, and here's why they work fairly quickly. Let me give you an example here. We'll come back to this page in just a second. But when we go to the, see if I can go to the listing agreement. Okay. You guys online, I know y'all can't see it yet because I have not shared it. Yeah, there you go. You should now see at the top of your page, exclusive right to sell listing agreement. And I have just suggested to you that it's not going to take a lot to learn this. Why? Because the listing agreement for the most part was changed to match what the offer to purchase changes were. Okay, so you'll see a little bit of yellow on here, and then hopefully you'll be able to recognize that change from the offer to purchase and contract. Just dates in the corners. Do you see the change there about fuel tanks and swimming pools? Same there. That was the fuel tank again. Attorney's fees and costs. If the seller wants to get out of this contract, they want to breach this contract. If you take them to court for your fee and they lose, they would be obligated to pay your court fee as well. And we also ask them to consider mediation as well. This is not marked out. This was moved to the end of the contract. Okay, so even that is same as it's always been. No changes here, looking good. Still nobody understands the office exclusive, but at least it hasn't changed this year. Okay. Fuel tank information, same as you saw on the offer to purchase and contract. I'm not stopping there. Seems like there was one more change here I want to point out to you. Oh, here's where it is right here. Okay. In deference to the fact that your clients do not understand dual agency, let me remind you where we are now. We're out of the offer to purchase, right? We're into the listing agreement. I don't know if you're aware of this or not, but your clients do not understand dual agency. And we are a large firm. So when you're filling out your agency agreements, I'm pretty sure that you're encouraging them to check dual agency, initial dual agency, and then of course, designated agency. Well, for years, agents have said, look, my client is okay with designated agency, but they don't want dual agency with one agent working on both sides of the transaction. But the way our old form was set up, if they agreed to designated agency, they had to agree to dual agency, and it didn't have anything to say that you couldn't practice true dual agency. And the people who wrote the contract, I asked them about this one time, the agency agreement, and they said, well, come on. I mean, no agent would hold them to it if it ever came up. I'm like, well, it's a legally binding contract. So in theory, the buyer wouldn't have a choice if the agent wanted to hold them to this. And so there were complaints by buyers. I thought I was working with two different agents. I knew it was the same firm, but I thought I was working with two different agents. It turns out that one agent was working both sides, and they couldn't give me the they couldn't give me the service I wanted because they were in that dual agency capacity. So what the attorneys did this year is they came back, they took the dual agent paragraph, and notice the way it's written here, dual agency, a lot of this, same wording, no problem. But when it gets to right here, there used to be that box and it had three choices. You could check dual agency, exclusive agency, or you could check designated and dual. So now what they've done is they explain what designated agency is. I would encourage you to read this. This is not a dual agency course, so I'm not going to spend a lot of time going over it, but they've put designated agency right at the top. And by the way, if you guys don't know what designated agency is, y'all need to come to me so I can help you understand what designated agency is. Designated agency means Christina and Inez are one for the buyer and one for the seller. Yes, they're the same firm. So I'm in dual agency as the broker in charge. I'm in dual agency, but she's designated for the buyer. She's designated for the seller. And in that capacity, they could work almost exclusively for their clients. You can advise them what to offer. You can advise them what to accept. If you learn that they'll offer more, you can tell your seller. If you learn that they'll take less, you can tell your buyer. That's designated agency. Not radically different from exclusive agency. I can see why buyers and sellers would be okay with that. But notice what it asks here as it starts getting down. An individual agent may not be designated to represent a party in a transaction if they already have confidential information. So seller, we're telling you here, we want this to be fair in designated agency. So what we're also going to tell you, look at dual agency option that they have now. Dual agency, seller authorizes the firm to act as a dual agent, but then look at what the very next question is there. Seller does or does not authorize the same individual to represent both the seller and the buyer. So what's that? I don't know why they could not have done this years ago, because this question has hung around for years. So the seller now will literally say, and I bet you that most of them are going to say, nope, I don't want you working on both sides of the transaction. And for most of you who don't practice true dual agency that way, you will be thankful, because what it'll do is it'll actually shows that you had no intent to do that. We do have some agents that do work on both sides of the transaction. It's fine as long as they explain that to the parties and they're comfortable with protocols associated with that. Okay. And then this paragraph below that as well. Also initial, a firm offers designated dual agency and seller authorizes designated dual agency as well. So it's getting back to the same thing. First of all, does your firm offer designated agency? And if so, is the seller willing to accept that? And then notice only at the end does it say exclusive representation. The recognition is that most firms today do offer some type of dual designated agency. So exclusive representation is thrown in there almost as an afterthought. If you were a firm that only represented sellers and no buyers, that's probably what they should be initially. Take a good look at that paragraph right there. And as Inez said, I think most of you will like it better over time. That is the big change in the exclusive right to sell listing agreement. Needless to say, it's the same change occurs in the buyer agency agreement as well. Okay, so I won't go over the buyer agency agreement.
Okay, now, what's up?
Hey, Marion, I don't know if you can tell or not, but your mic is on.
Oh, she's on a month to month.
Yes.
Oh,
So you can terminate the contract. You can say she has 3.
I just muted everybody on that. So if you need to, chime in. Just make sure you click the chime in thingy. Okay. We are almost finished here. I'm not going to spend a lot of time on the termination paragraph because I had mentioned this to you a little bit earlier. If your seller wants to terminate this contract, they do not have a legal right to terminate a listing agreement. Okay. They don't have a legal right to. That doesn't mean they can't terminate. It just might mean that you have options that you could go back against them for money for your time, your effort, your open houses, or literally your commission, depending on where you were in the transaction. And then what we're going to talk about here in C is, of course, that if there is a dispute in regards to the termination of this contract or the money involved, seller, we're going to go to mediation before we start suing each other, okay? And then notice that they specifically, the attorney's fees that we skipped earlier, they have been moved down to this paragraph. You can see mediation is no longer a paragraph by itself because they moved it up into the paragraph that we just discussed. Yeah. It's in the, it's always been in both contracts. The wording just slightly different, but the sellers and buyers have never had a right to unilaterally terminate these exclusive agreements, okay? Now, granted, we don't always go after people when we could, but if you have a real good case, this is the paragraph that says, hey, seller, you knew that this was a binding contract at the time you signed it, and here's the way we're going to deal with that. The note down here on the bottom looks like it would be very important. What it actually is, do y'all remember that there are places in the listing agreement where it says, hey, seller, I gave you a copy of the home inspection or the questions and answers about earnest money or whatever. We've just now moved those into one note and said, seller, if you're interested in these documents, they live at the ncrec.gov on the website. Just go get them. They're interactive and you can get them that way. You don't have to worry about printing copies if you don't want to. You can just provide the link or PDFs for them. They're actually good brochures. I kind of like the fact that they exist. Nobody's going to read them except engineers maybe, but I do like the fact that they exist. Okay, questions or comments so far? You in good shape? Christina, have you seen anything that's worried you yet? Okay, there's nothing that'll worry you. In case somebody has to jump off, I'm gonna go about 3 minutes long, it looks like, but in case someone has to jump off, let me remind you, anytime that there are new forms, there is a grace period of 60 days. So in theory, you could keep using the forms that you have all the way up to the end of August. Someone usually asks, well, will DocuSign update? DocuSign will update, probably not on day one, but very quickly, DocuSign will update the new forms, which is a little bit of a pain if you have templates built. You may have to go back and build new templates for the new forms, and then they'd be good for the whole year, of course. If you use .loop, we have no control whether .loop updates or not because we don't use it as an office, okay? So you would need to contact .loop and make sure that they're taking care of getting you the new documents. They have up to 60 days though, so don't panic if you don't have these on July 1st. I'm going to show you the form here. And again, you can get this at ncrealtors.org, and I will post it again saying that we've had another class so that it's available for you. Also, this is being recorded, so this is available for you. There was a change in the the offer to purchase and contract for vacant lots, Form 12P, but it's actually all it did is emphasize the fact that there's a North Carolina statute that says if you're going to buy and you're going to subdivide property, you need to be aware that there's a state law that governs the subdivision of properties, just like you guys learned about in pre-license class. That law actually exists. In the backup contract, remember on a backup contract is one that you would be writing an offer on a house that's already under contract, okay? And so one of the things that they've changed there, you can see I have it highlighted here. This is not the actual wording, but we'll show you the main thing that was changed. It was updated to reflect that the primary contract has been terminated and removes the mention of the seller as the terminating party. In other words, the backup contract, it has to tell the backup buyer the possibility of them becoming the primary contract. You are not the primary contract until there is evidence that the primary buyer has terminated. And on the contract itself, it actually describes what that would be, like a termination form or a release of earnest money or something like that. So it's very specific about when it's terminated. Apparently, people are struggling using the new construction addendum, and you will as well in the near future, because a lot of builders now are building spec homes. You know, and so in other words, they've already spec'd out the house to try to control the costs, so they're not dealing with a lot of upgrades. If you're buying that house and the builder does not have his own proprietary form, what you would use is the standard offer to purchase and contract. And by the way, I know your eyes are starting to glass over because we've been talking about contracts for an hour, but let me remind you on the first page of the offer to purchase and contract where it talks about your earnest money, your due diligence, there's also a spot down there for a builder deposit. And it actually mentions these forms by name. Do you need Form 800, which would be to build a home, or do you need standard Form 2T with a new construction addendum 2A3T? And it'll actually say down there, see attached form or something like that. So in other words, if you put down a $5,000 builder deposit, then you're probably also attaching 2A3T to the contract as an addendum. And what it'll allow you to do is even if there are minor adjustments that need to be made, it allows you to address those. But the one reason that you need to use this form if you're buying new construction, even if it's spec, is because that's the form that mentions the builder's warranty in it. And so without that, there's no guarantee that a builder is going to provide a warranty. There's technically no guarantee he's going to provide a warranty anyway, but at least if you attach the new homes construction addendum, it's addressed and they would literally have to mark it out if they were not going to provide the warranty.
The addendum you would use would still be the new home addendum.
Correct. If you're buying a new spec home, Form 2T, standard offer to purchase and contract with the addendum 2A13T, 2A3T. Okay. Yeah, a lot. Correct. Well, I mean, if for some reason a seller had purchased it and never lived in it, then no, it would not be under the same situation. I think it's safe to say in every case on this, you would be buying it from a builder. Okay. The possessions, let me mention to you both buyer possession and seller possession. This literally came to our attention, 3 or 4 weeks ago, that the wording in the possession agreements is woefully short of what you would have if you had a rental agreement. So this just pointing out to buyers and sellers the repercussions of this. For example, notice that there's a warning now in the buyer possession before closing, and it comes up in the seller possession as well. Warning has been amended to specifically mention security deposits. So think about this, a buyer possession before closing. Why would a seller ask for a security deposit? Well, what if the buyer doesn't close? If he doesn't close and you got to kick him out, it'd be nice to have a security deposit to kick him out. Same thing with a seller possession after closing. He said he was going to move out in 30 days, but as it turns out, he keeps staying and staying and staying because his new home is not ready yet. So there was no reference to a security deposit. So that warning actually mentions this. If you want to address that, you need to have something drafted by an attorney or use a residential rental contract. Similarly, in paragraph 1, the new paragraph added gives the seller a right to access to the property in case of an emergency. There has been a big controversy lately in regards to these possessions other than closing. And the question was that came up was, well, if the seller stays beyond closing, does a buyer have a right to the keys and the ability to access the property? And the answer, according to the attorneys, was no. So what they've done now is they've addressed this in the contract and said, you know what, we do believe that the owner of the house should be able to have a key to the property and have access for emergency purposes. So going forward, the contract will actually address that, not deeply. If you need it addressed deeply, you need a rental contract.
So that's just for emergency. So there's no one go and measure, so you get estimates, that's up to the.
And clarify that all means of access to the property are to be delivered to buyer at commencement of buyer's possession. So the only thing it specifically mentions is in case of emergency. Everything else would have to be by negotiation. Hey, I know you're living in my house now. Would it be okay if I come by and measure for curtains? No. Okay. Well, in that case, I'm going to burn the house down because then it's an emergency and then you have to give, no, don't do that.
So
Right the way I think.
at the closing table, they are entitled to.
According to this now, and the question about the keys had to do with delivery of the property, including keys and garage door openers and stuff like that. So now the seller is entitled to retain an entry key.
Except for Keisha saying specifically
Yeah. And that's the difference in the old wording versus the new wording. Apparently this was controversial before I even knew it was controversial. Anyway, those are the major ones that I wanted you to see there. And when you look at this form, you'll see that there's a lot of verbiage on it, but most of the time it says, see discussion of change paragraph 1D of all or 2T. Most of these forms relate directly back to the offer to purchase. And so you don't have to remember everything that is on here. So with that being said, that's the hour that I needed to get you through. And remember this, July 1st, that's the new contract. You're not required to use it until September 1st. Give DocuSign a little bit of time to update this. Don't panic until that time. In theory, this should be available July 1st on the Association of Realtors website. So if there's something in here you like so much better than what you're currently using, there's no reason you can't download it and use it at your discretion at this point. If you use the new form though, you have to use the ancillary documents that go with it. In other words, you couldn't use a 2021 offer to purchase contract and a 2022 additional provisions of it. Just make sure that they're matchy-matchy, okay? Any questions online? In that case, we are out of here. Thank you for your time today, guys. If you have any questions, stop by my office. I will be glad to entertain questions there.
Thank you so much.
Thank you.
Thank you. Bye.
Bye-bye. Thanks. I need to stop recording. How do I stop recording on here?
But you know, in pre-licensing, they said that the real